Sources of Hindu law. Hindu law is considered to be the most ancient and prolific law in the world. It has been around every phase. Hindu law was established so that the people will follow in order to attain salvation. Originally, Hindu law was established so that the need of the people gets fulfilled. The concept was initiated for the welfare of the people. Broadly, there are two categories which the sources of Hindu law can be divided into. That is, ancient sources and modern sources. Ancient sources of Hindu law. Ancient sources refers to those ancient Hindu legal system which governed the conduct of Hindu at that time. It is further classified into four categories: Shruti, Smriti, customs, digest, and commentaries. Shruti. The term Shruti means what has been heard. It is considered to be the primitive source containing the knowledge of law. It contains the sacred words of the god. This source is considered to be the most important and essential source of all. Shrutis are the sacred pure utterance that has been enshrined in the Vedas and Upanishads. They have religious connection with a person and help him in a way to attain the knowledge of salvation and incarnation. Smriti. Smritis are considered as what was remembered. Thus, Smritis are known as golden era because it is an era when well organized dependent on the remembrance of the sense and the era of creation of and serial wise development of Hindu law started. It is the second important source of Hindu law as a text which has been remembered and when interpreted by the rishis throughout the generation. There is a further classification of the term Smritis, which are as follows: Dharma Sutras and Dharma Shastras. Dharma Sutra, prose. Dharma Sutra are famous for Gautama's Buddhayan, Apastam, Harit, Vishnu, and Vashisht. Dharma Shastra, poetry. Shastras are famous for Manusmriti, Yagyavalkya Smriti, Narad Smriti, etc. Digests and commentaries. The third ancient source of Hindu law is commentary and digests. Commentaries and digests have explained the scope of Hindu law. It played a major role in developing the very concept of Hindu law. It helped in interpretation of Smritis. Single interpretation of Smritis is called commentary, while different interpretations of Smritis is known as digest. Dayabhaga and Mitakshara are considered to be the two most important commentaries. Customs. Customs is a tradition that has been practiced in the society since the ancient times. It is a type of practice which is under the continuous observation of the people has been followed by the people. Further, the customs have been classified into two categories: legal customs and local customs. Legal customs. Legal customs are those customs which are enforceable and sanctioned by law. It can't be deemed invalid until the law itself declares it invalid. Local customs. Local customs are the customs that are practiced in local areas. This type of custom is not highly recognized. Another source is modern source of Hindu law. Modern sources of Hindu law are divided as follows: precedents, justice, equity, and good conscience, and legislation. Precedents. Precedent means decision given by superior courts. It is binding on inferior courts and to be followed in future in similar cases. Doctrine of precedent brings certainty, predictability, and uniformity in law. Judicial decisions are considered to be the most important ingredient of modern source. Judicial decision is considered to be the authoritative and binding. The doctrine of precedent was established and it was applied in the cases resembling the same facts and circumstances of the case already decided. Justice, equity, and good conscience. Justice, equity, and good conscience is the basic rule of law. This rule of law applies when existing law does not apply in a case before the court decides the particular matter by applying its rationality and the concept of justice, equity, and good conscience. This rule is considered to be the fairest and reasonable option available to a person. Legislation. Legislation is a vital source of modern Hindu law. During the British period, only very few legislations were passed touching the personal laws of Hindus, in tune with the British policy of non interference in the matters of personal status of native Indians. It is considered as a base for the growth of Hindu law in the modern world. It has been stated that in order to meet new conditions of the society, it became a necessity to codify the law. And here we reach the conclusion, which says that Hindu law is considered to be the most ancient and prolific laws in the world. It has been around every phase. It is around 6,000 years old. Hindu law has been established by the people not for the purpose of removing any crime or transgression from the society, but it was established so that the people will follow it in order to attain salvation. Originally, Hindu law was established so that the need of the people gets fulfilled. The concept was initiated in for the welfare of the people.